Hello, welcome back to the 10,000 Startups podcast. My name is Roger Royce. I am your host. I'm a partner with Haynes Boone. In Palo Alto, I do emerging growth and venture capital law. And today we're going to talk about the Nevada question because this is an important one and one that has been in the news quite a bit lately. Now, it just seems that for a long time, almost all the time, people, when we formed a company, um, the state of the art incorporation jurisdiction has been Delaware. No one debated that. Nobody questioned it. The documents assumed it. The investors expected it. And I'd have looked at you funny if you asked me for anything else. But not so much anymore because in the past year or two, founders have been asking me on formation whether they should be a Nevada corporation or a Delaware corporation. Investors have asked whether Nevada is a diligence flag. And you know what? Public company boards have actually even moved there. We've got several previous webcasts and podcasts on this topic. But today I want to drill down a little bit and show you both sides of the table. Founders deciding where to form, funders deciding how to react when they see a portfolio company that's formed in Nevada or wants to leave Delaware. And the story you're going to hear from me might be a little different than what you've been hearing from everybody else. I am a Nevada licensed attorney. I actually formed Nevada companies, so I got a little bit of background on this. And I'll tell you that the Nevada story is sometimes oversold and sometimes not. It depends. So let's talk a little bit, first of all, how Delaware became the default. Well, quick history. Delaware won the incorporation market decades ago with a very flexible statute, a specialist court called the Court of Chancery, and a huge library of decisions that lets sophisticated lawyers predict the outcomes, right? Venture capital grew up inside that system. The National Venture Capital Association, NVCA model documents are Delaware documents. And your Series A counsel on both sides have learned their craft on Delaware opinions, regardless of what state they might have been sitting in. So the network effect has been a real thing in making Delaware the default. And it's not really that the statute's magical. It is that thing that in blockchain we call network effect. Well, what cracked it? But first of all, there were a string of Chancery Court decisions that the founders and the backers read as judges being a little more activist than they'd like and overriding choices that stockholders had blessed and reshuffling economic decks that have already been dealt. The Tesla pay case got all the headlines. Remember, Elon Musk tweeted, "Never incorporate in Delaware." But really, the broader complaint from the founder community was that Delaware litigation had become a cost of doing business, with stockholder plaintiffs' firms treating every deal and every controlled transaction or controller transaction as a fee opportunity. So Delaware noticed, and in 2025, the legislature amended its statute to create some safe harbors for transactions with controlling stockholders and to narrow books and records demands, which can be hugely annoying to a company that's just trying to do business. Texas launched a business court and it rewrote chunks of its entire corporate code to deal with this perceived need in the market. And Nevada, which has been quietly building a statute first system for 20 years, suddenly had a marketing movement, or a moment, I should say. Major tech companies reincorporated there, and one of the most prominent venture firms in the valley publicly endorsed the move. Whoever thought that would happen? So the market's gone from one option to three options, and the choice carries some real consequences. So, what are you really choosing? I mean, strip away the politics, and here is the actual choice. Delaware gives you this statutory skeleton and lets the judges put the meat on it. Okay. And there are hundreds of cases putting that meat on the bone. And some people might not want to have to sift through hundreds of cases to find out what the law is. And that's Nevada's advantage. It writes the meat right into the statute and tells the judges not to improvise. And the second part is literal. The corporations code in Nevada says that the duties of directors and officers are defined by the plain text of the Nevada statute and cannot be expanded or modified by the law or court decisions of other states. Now Nevada does have courts, of course, and there is a Nevada Supreme Court line of cases holding that the statute is the only path to personal liability for directors and officers, and expressly declining to adopt Delaware's layered standards of review. This is huge. And this is why I tell people, as a general matter, Nevada is very management friendly. And Delaware is very shareholder protective at a high level. Now, for a founder, the translation is that in Delaware, if you want to know how exposed you are, you go ask a litigator who's read the last 5 years of Chancery opinions. In Nevada, you read the statute. And predictability is the product Nevada is selling. And for an operator who'd rather run a company than fund a litigation defense, that's a real product. Now, for an investor, the translation is a little different, right? Delaware's case law is a tool. When you need to discipline a founder who's self-dealing or hold a board to a process, Delaware gives you doctrines built for exactly that: entire fairness, enhanced scrutiny, demand futility, etc. Nevada gives you a statute that was written on purpose to make those claims hard to bring. Now, you might see that as clarity. You might see that as lost leverage. Kind of depends, which hat you're wearing. So keep that tension in mind. It kind of runs through all of this. From the founder's view, personal liability is what founders actually care about, kind of bottom line. And in Delaware, the baseline is that a director can be personally liable for duty of care breaches if they were grossly negligent, for breaches of loyalty. Almost every Delaware company fixes this problem with the charter provision exculpating directors. That means basically making them not responsible. And in the last several years, they do that for officers now too. They're carefully drafted documents. That provision doesn't affect the breach of loyalty claims. And plaintiffs have become very good at dressing up care claims as loyalty or even bad faith claims to get around it. And bad faith is supposed to be a gap filler, but you can intuit that it's been expanded sometimes. Now, Nevada's baseline, on the other hand, with no charter language at all, is that directors and officers are presumed to have acted in good faith and on an informed basis, and that they're personally liable only if the plaintiff proves a breach of duty, and that breach involved intentional misconduct, fraud, or knowing violation of law. So what's the big point here? There's no carve out for loyalty. That same high bar covers everything. That's a big difference. So what does that mean? Suppose you're a founder, CEO, and your board approves a pivot. You shut down one line to chase a different line. It happens all the time. Or your stock craters because of it, and the stockholder sues. So in Delaware, that case gets filed, everyone gets deposed, and you might settle for defense cost reasons if you'd ultimately win. Now in Nevada, the plaintiff had better be able to plead fraud or intentional misconduct and kill that case, or that case will die at the pleading stage. So Nevada is designed to let boards take big, good faith swings without treating every miss as a lawsuit. I'm full of metaphors today. Nevada adds one more thing that founders really like: a constituency provision. Directors can weigh the interest of employees, customers, communities, the long-term health of the community, etc., alongside stockholder value. If you've been considering a public benefit corporation to do that, note that Nevada gives you most of that at baseline without PBC reporting overhead or investor issues. So something to keep in mind, because the general rule has always been that directors have an obligation to maximize shareholder wealth. Well, here Nevada, plays with that rule. You might think of it as an upgrade to capitalism. So, but the honest caveat here is that a high liability bar is not immunity, right? This is not licensed to commit fraud. Fraud is still fraud. And courts will enjoin or unwind a transaction, even if they can't impose personal damages. But the day-to-day exposure of a Nevada director who made a good faith but bad call is way lower. Now let's flip the chair. You're wearing a different hat now. Suppose you're the investor. What does Nevada do for you? Well, first, sale processes. In Delaware, once a company is up for sale, the board has to run a process that holds up under enhanced scrutiny, and a conflicted deal gets what they call entire fairness review unless the company builds in some safe harbor protections. Nevada is way less complicated. It applies that same deferential business judgment as opposed to entire fairness standard to a sale that it applies to any other board decision. There's one exception, it's very narrow. The board can't use defensive tactics to block stockholders from voting for or removing directors. So entrenchment, you might say, is policed, but everything else is business judgment. Secondly, for controlled companies, a lot of venture backed companies are founder controlled through maybe dual class stock that we've talked about, or maybe just a big founder block. So in Delaware, what does that remind you of? In Delaware, transactions between the company and that stockholder controller are the most litigated category there is, probably. In Nevada, the controller gets the same presumption as everyone else, unless you can show intentional misconduct or fraud, right? So if you hold preferred stock in a founder controlled Delaware corporation, your protection against a sweetheart controller deal is going to come from your documents, the protective provisions, the consent rights, the committee requirements, and not from the courthouse. And then third, the holding company and fund layer vehicle. So Nevada LLCs since 2019 own no fiduciary duties beyond good faith and fair dealing unless the operating agreement creates them. Delaware is a reverse. Duties exist unless they're waived. So if you're a minority member of a Nevada LLC and your agreement is silent, you have very little leverage in that scenario. It's really important to read those documents and read it again. That's the holding company fund vehicle layer. Now, the practical upshot for investors is that your Nevada charter isn't necessarily a red flag, but it does shift protection from the judge to the drafter, and your lawyers probably should be pricing that into the financing documents, because things you used to get for free, you now have to write into the documents. Loyalty, a standard for conflicts, etc. The way I'd actually decide this question probably depends a lot on stage. And pre-seed and seed, expecting an institutional venture within 18 months from now, I would form in Delaware. Even though I'm a Nevada lawyer, I would form in Delaware. And it's not because it's better, because it's frictionless. Every fund's form documents, every convertible note template, every safe that you went and downloaded off the internet because it's just so easy, that's all drafted for Delaware. Nevada charter at this stage probably invites a diligence conversation you don't need. And some funds are just going to make you go to Delaware in order to close the round anyway. The important thing is you can always convert later, and it is a simple process. Now, if you're at Series B and beyond, you're founder controlled, you got a board that wants to make some, long-term bets. This is where Nevada, gets to look really good. Your cap table is sophisticated enough to negotiate protections into your charter. The liability and litigation profile matters more as your stockholder base grows, and the reincorporation path into Nevada, and that can be by merger or statutory conversion, depending on the state, is pretty well established. Although, frankly, to be honest, I spend most of my time migrating companies out of Nevada into Delaware than I do vice versa. So if you're approaching a public listing, Nevada also deserves a hard look. The companies that have actually moved there are public or late stage. They've done it with institutional holders voting yes. In one set of proxy materials, the argument was that Nevada statute provides a more stable environment for fast corporate decision making. So that's a good use case. If you're closely held, bootstrap family businesses, you're never going to hire a lawyer to try to opt out of Delaware's defaults. Well, Nevada's defaults were written with you in mind. You get that sophisticated company outcome without having to pay for it. Mission-driven companies that want stakeholder flexibility, Nevada statute is a much cleaner answer than the public benefit corporation statute for a lot of them. Now, there are a few traps that I would be remiss if I did not mention, and three in particular. So number one, if you think Nevada law is the only law in the room, you would usually be wrong. If your company is headquartered in California with mostly California stockholders, our California Corporations Code, Section 2115, will apply parts of California law to your company regardless of where you're incorporated. That could be a whole hour on itself, just these quasi foreign corporation provisions, what's internal governance and what's law of the place you're doing business. That's also true of Delaware, by the way. People tend to forget that. So, securities law, employment law, contract rights, they don't change just because the name on your charter says Delaware, California, or Nevada. Number two, there's a tax myth that I've been fighting my whole career. Now, Nevada has no corporate tax. Okay, yeah, we all get that. And people say, oh, well, if I move my company to Nevada, I save on taxes. And the answer is no, not one little bit, because your state taxes are driven by where you operate, where you sell, where you employ people, where you have property. It has nothing to do with where you filed your articles. So if you're a Nevada corporation headquartered in Palo Alto, you're going to pay California tax. And by the way, for the QSBS people, remember that's a federal statute that similarly is indifferent to your state of incorporation. So you're not going to get that. California doesn't have a QSBS provision. Having a Nevada corporation isn't going to get it for you here in California either. And then trap number three, we'll just call this, for lack of a better word, the sloppy reincorporation. When you do move to another state, keep in mind that is a transaction. You do need stockholder approval. You need to think about appraisal rights. People tend to forget that until they get to demand. You'll need to repaper the equity plan and the option agreements. You'll need to update all your records, refresh the financing documents, look for change of control or assignment clauses. You have to look at lines of credit and leases to see if that creates a default or default interest or requires notice or consent. So it's not as easy as I might have made it sound earlier. So it really has to be done with counsel who actually practices in Nevada. So keep that in mind. But if you remember only a few things, I'd like you to take away these four things. So number one, Delaware is still the default. Okay. And that's frankly more about lack of friction than it is about merit. Number two, Nevada trades judicial oversight for statutory predictability. Founders get a high bar for personal liability in Nevada. Investors get less help from the courts and have to write their protections into the documents. Number three, the Nevada case gets stronger with stage. Founder-controlled, late-stage, public or closely held companies are a natural fit. And number four, incorporation doesn't change your tax home, your California exposure, or your QSBS status. So don't let anyone tell you different. So for the first time in a long time, maybe ever in my career, I'd say the state of incorporation is a real issue that's up for grabs. I think you should make it on purpose and with intent. So keep that in mind. I'm Roger Royce. Thanks for watching 10,000 Startups.